So basically, as Gordon was saying, is that there is a really strict US law which you have to comply when you sell securities. And I'll be more specific to tokens and ICO, because everything that was explained to you before, yeah, it relates to securities, but we are here mainly to hear not about stocks. We are here to talk about ICOs and issuance of tokens. And basically, the tokens could be considered securities under the US law in multiple ways. And as Gordon was saying, there is mainly they could be considered securities under the definition of an investment contract under the Howey test. However, what was later, if you can see in some cases that were brought against the companies by the SEC recently, we can see that actually it's not only the token model where the company offers a direct profit. It also, the definition of investment contract also would apply to the actual sale, how the sale is performed, and what exactly the representations that are made by the company during the sale. I'll give you I'll go over a few cases, and I'll tell you the difference between them, and I'll point out the important things about those cases. So if you are interested in conducting your ICOs or actually buying tokens, you can look at those things, and I'll tell you why. So, from one standpoint, if you are a company that is conducting ICO, you want to make sure you do things right, because, as Gordon mentioned, the SEC has really long arms. The SEC works with a lot of authorities all over the world, and they've had multiple cases when they worked with Mexican and Canadian authorities, and they brought charges against companies that had that been registered not in the United States. And so in those regards, if you're a company, you want to make sure that you comply with the United States law if you decide to sell to the US residents, whether it's in the United States or outside of the United States. And if you are, so basically if you don't comply with the US law and you sell to the US residents, then there will be down the road, not necessarily today, tomorrow, or next year, it can happen to you later down the road when your tokens go down in value, when there are whistleblowers, when someone else complains. So multiple things could be a trigger when SEC will start conducting an investigation of a specific ICO. So it's interesting how, like, a couple years ago, people would just say, well, it's unregulated market. And very few lawyers who were around a few years ago were saying, wait, guys, we have a securities law, it applies. And I was saying, no. And I've had that. Like, clients would come to me and I said, yes, you need to comply with the US law. And everyone would say, like, no, look at the Dow, look at all the startups that are like raising funds, they're offering profit, they're raising capital. They don't care, look, there's no enforcement. And then boom, in the middle of 2017, there was a first case. It was related to the Dow. We've learned today, if you were part of the if you were in the audience during the previous presentations, we know that the first ICOs started many years ago. But the first press release that was issued by the SEC was actually made in 2017. So years after the ICO started. The SEC took a very long and sweet time to learn about the market and understand how things are working, and before they actually decided to speak out about it. So the first case was relevant to the Dow, which raised, I believe, $160 million or something like that. And the SEC concluded that, yes, in fact, those tokens were securities, and the US law had to apply to those tokens. So now, of course, the Dow had multiple issues with not just relevant to the sale of tokens, unfortunately, but the SEC did not they did not put any penalties, they did not do anything to the company because, it was the first case. Truly, lots of companies didn't know in the market, and they realized that the Dow was not a fraudulent ICO. There was when they were issuing those tokens, there was no intent to damage anything. So they really wanted to make an example out of it without applying any penalties. So the Dow somehow got away easy with this stuff. But then think about it. In some situations, this is for the company, but the US can actually penalize the companies. And as Gordon was mentioning, there could be very severe civil penalties. In case if there's a fraud, which is a separate kind of scenario, and I'll talk about it later, they can refer to the Department of Justice, which can bring criminal penalties. But still, you know, when you're dealing with the SEC and with the investigations, which can go up for many years, and the SEC has the power to bring up lots of like civil charges, and they go to court, they file complaints, and you know, they can, you know, they can freeze the assets, for instance. So if you're a startup that issued security in violation of the United States law, well, later down the road, something can happen to your actual business when you decide to build up the company, use these funds that you received, and you might not have it available because the SEC will conduct the investigation and intervene with your business. Now, if we look from the standpoint of the buyer of the tokens, you're also risking a lot. If you don't do your due diligence, if you don't really know the law, and you are, even if you're not a US resident, let's say you're buying tokens of a startup, and then later it will turn out that this startup violated the US law, and now they're subject to investigation. What do you think is going to happen to your tokens? They're not going to go up in value. Most likely, they're going to crash. So you're going to lose your money. And that's why it is important to understand the ramification of all this. It applies equally to the companies that violate the law, and it applies to the investors who just simply bought tokens without knowing how the law would later apply. And if we look at the situations right now, I can tell you that the SEC is conducting, I believe, over 200 investigations. Am I right, Gordon? Do you have the same number? Yeah, so most of them are conducted in private, so you will not hear about it. And I can tell you, probably not like we've seen, there are so many startups that conducted the ICO. Not all of them are being investigated, but a lot. And a lot of those who have some sort of connections to the United States, they are under investigation. Many of them, not all. So, and it might take years. It might be, we might hear something next month, 2 months from now, but for most of them it takes years, especially if there is no outright fraud involved. But what we see currently with the pattern, the SEC is really investigating most of them that have some sort of a signs of fraud, or they look like a scheme. In 2017, after the DAO, which was not a fraudulent one, but the SEC decided that the DAO tokens were securities. After that, the SEC issued a couple of press releases. The chairman, Clayton, spoke about it. There was an investor's bulletin. So there were multiple documents issued by the SEC and other financial regulators to educate the market and educate the investors. There was one interesting case that I'd recommend everyone who is interested in conducting ICO to read. It was there's a press release on that as of December 12, 2017. It's related to the Munchie case. It's a California-based startup. Their token model was a utility token, if we look at it. They never offered a direct profit. However, when they were selling their tokens, they were talking about, hey, our tokens, they're going to go up in value. You'll profit from trading it on exchange. They were making all these representations, not offering the direct, some sort of a profit from ownership, from, let's say, the company would not distribute any financial gain or any income to the holders, but they were implying, and they were making multiple statements over the media and social media saying, yeah, bio tokens, they'll go up in value. So the SEC decided that that is an offering of securities. So they halted the ICO, and Munchie agreed to return all the funds. I believe they raised close to $25 million or something like that. So the company agreed to return all the funds, and they avoided the penalties, and the SEC did not press any charges. But that was at the end of the last year. Also, what we've seen in the last year, there were a couple of cases where the SEC alleged fraud, and they filed claims. They filed complaints in the U.S. courts. This year, the situation continued. So if we look at it, we've had in January and February, then April and May, there were 4 cases against different companies for fraud. So almost every month, I haven't seen anything since May, but almost every month there have been a case where the SEC is issuing press release after they brought a file a complaint for fraud. And in some cases, in all of those cases, they work with different authorities, and in some of those cases, they actually bringing DOJ on board, which means that there could be potentially criminal charges. So also, what's good to mention about the SEC is that most of their cases have nothing to do with the ICO, because we have regular stocks. We have so many participants in the regular stocks and securities market. So the ICO is actually, or the SEC is actually focusing on enforcing law against those. And if we look at it, most of them go for like insider trading and market manipulation. To this point, it's not relevant yet to the ICOs, although we do see SEC starting to be interested in those cases as well. So far, we see only enforcement cases that have to do something with the actual issuance, and it's unlawful issuance of securities, something that has to do with fraud, like misrepresentations, and we haven't seen yet anything that had to do with the ICO market manipulation. I believe the SEC is also involved in Bitcoin market manipulation, but nothing yet with the ICOs. But I'm sure it's going to be somewhere down the line. So basically, what's good to remember is that there could be two cases where the SEC can get involved. One is that when the startup unlawfully issues the securities, basically in violation of the U.S. law, where under the U.S. law it's considered an investment contract, but the company does not register the offering, or it does not fall under one of the exemption, and one of those Gordon just explained to you, Reg D. There are a few more, and if it's not correctly registered, if it's not correctly performed, then the SEC can actually get involved and investigate for unlawful sale of or unlawful offering of securities. A second case is that when you actually decide to raise capital by using the law, U.S. law, and comply with it. So let's say you raise funds under the Reg D and everything is great. Here where you're facing something mainly is going to be actually, now you have to comply with the securities law. Now you are facing actually those things that have to do something with misrepresentations. Did you disclose everything in your prospectus? Did you allow any market manipulation? What happened to your tokens? And that's basically, we haven't seen yet any of those cases because there have been very few offerings that are actually done under Reg D, and a lot of them were mainly private offerings, so we haven't seen them yet. But I'm sure there will be more cases as that. You can actually, if you're interested in that, SEC publish a lot of information on its website. You can go to sec.gov. Also, with my team, we'll look at the different information that is available in the market. We analyze it and we put some updates on our website. You can go to blockchainlawgroup.com and you can look under the tab news. You can see some information of what's happening actually. We mainly focus on CFTC and SEC information, but it's also, as you can see, the broader things get, you see more and more different authorities being involved in investigation of the cases, because nowadays, it used to be more like just tokens. Now when the tokens actually go into real world and real market, real sectors, there are other authorities that get on board in investigating of certain things, including for fraud and including for unlawful actions in violation of the U.S. law. And pretty much that's it. So if you have any questions, you're welcome to ask them.
Thank you very much for your presentation. I work for Tokenite. We tokenize assets, utility token, security token, and we've been borrowing Lysium security token offering, which is 250 million private, under Reg D to acquire real estate in Manhattan. Now there's a big thing in this industry where exchange are claiming they're going to list those tokens, because for the moment, of course, we have the lockup period. What's going to happen after the lockup period? Because those trading exchanges should be regulated. Who will be able to buy those stocks? As an accredited investors, will you be able to trade the security of those exchanges, or will it be limited to people that have a proper license, like brokerage?
You know, to my knowledge, there is no exchange that deals with the U.S. residents yet, and that is licensed to offer securities, like tokens as securities. Do you know, Gordon, of any of that? Because I can tell you it's very difficult to qualify as an exchange and get a license because the requirements were written for stocks. With the problem, in my opinion, the main problem is that with tokens, you can have transactions where I can transfer my tokens to you privately. You cannot do that with stocks. And you cannot really, for the exchange, they're also responsible for avoiding market manipulation. There are so many requirements to the exchanges. That's why it's very difficult for anyone to qualify and get a license under the exchange. That's why all the tokens that are issued as securities, there are a few, but they cannot be traded anyway. There is no exchange for U.S. residents. I know that, for instance, there are a bunch of tokens that under the U.S. law they would qualify as securities, but some foreign exchanges accept them for trade. But again, it has nothing to do with the U.S. Those exchanges, they don't deal with the U.S. residents. And a lot of those companies, they don't even sell to the U.S. investors. So you see different things on the market. But if we talk about the properly issued tokens under the securities law of the United States, there is no mechanism to trade them yet. So once this period lapses or goes over, whatever, 1 year, if there is an exchange, there will be a mechanism how investors can register with the exchange, put it on exchange, and then they'll be able to trade it through the exchange. But at this point, there's none. And this is one of the issues why many startups, they have great product, they want to raise capital, they have like really good projects, but it's not very attractive to a lot of investors, to public, because they cannot do anything with tokens. That's why those companies, they go private and they raise funds from typically from, I don't know, wealthy individuals or family offices or crypto funds that will hold these tokens for indefinite time, and they provide this disclosure that there is no mechanism to trade them.
Thank you, Katrina, for your speech. My name is Dennis, and I represent Cymex. One question to you, for example, if we don't try to get our own license, but we use, for example, a broker-dealer license on the US market, in like a partnership or under their license, or under their license, will we be able to trade tokens for US citizens?
You being who? An exchange?
An exchange, yeah.
Well, for the exchange, it's the same thing. Brokers, they don't trade. You know, brokers do different things. You can't really trade anything through brokers, if you think of it this way. You can have broker services as an issuer and to offer, let's say, your securities through brokers to accredited investors, someone like that, because you have to have licensed people offering securities. As an issuer, you can do that, but you cannot, like, there was another case about celebrities, where people are, you know, startups, they bring celebrities on board and they say, oh, go and promote it. You can't really do that when you deal with securities. You have to go through licensed individuals. But I don't think it's applicable to the exchange, because as exchange, you have to have your own license. It cannot really be done through brokers. That's my opinion.
Yeah, hi. You and Gordon have done a marvelous job. Now, my name is Anya Hansen from Global Tech, UK. The question I was going to raise is there are far more implications if you have utility tokens. So, do you think that a promoter of an ICO can actually avoid that by classifying those ICO as equity tokens?
If you have, I'm sorry, can you repeat your question? It's opposite, right? You meant probably opposite? Could you please do it again?
Rather issuing or classifying the token under the ICOs as utility tokens, can you classify them as equity tokens?
It's not like how you choose to classify. It's what right do you give to your token holders. As an equity token, you have to give them equity. if you're doing a utility token, it has to be something that you can utilize. There's no equity. There's the right would be a right to use it for something. In the equity token, you give them equity, and equity is a security. Utility token is not.
Okay.
So you probably meant opposite. When can you have a security token? Can you classify it as non-security token? That's what you was trying to say?
That's on that.
Yeah. So again, this has to do with the actual model. And as I was saying, that sometimes it's not like you can classify it, but when I work with startups, and it's good when the startups come to lawyers ahead of time before they actually start the ICO or complete the ICO, which is worse than anything. You know, when they have an idea, they have a model, they come to lawyers, and we lawyers, we sit down with them and we discuss, and we give them the risks, and we explain how the model, what law would apply to their model. So sometimes, you know, there are startups that have an idea of offering profit, let's say, or offering some equity, and we would say, well, if you look at it this way, if you make an offering like that, then it would be security. Are you willing to raise this portion? Because some companies, they already have a built built platform. So they're not raising capital, they're actually trying to sell the product. So it already eliminates the idea of raising capital, which is good, it's halfway through. So if the startup is willing to modify the model and make it a useful model, yes, sometimes it's possible. But it has to be done before you start any sales. You cannot just say, oh, well, why don't we just classify it this way? There's no argument for the SEC in the way where it's like, well, we thought of doing it this way. You actually have to have a model that looks like a utility token, that has no elements of security. And when you sell this token, you cannot sell it as a speculative instrument, even if it's a utility token, just like in case of Mindchain. Did I answer your question? Good. Thank you, everyone.